Hey patent friends, welcome back to another video coming to you today from Puerto Vallarta, Mexico. I'm on vacation and working remotely a bit, and I wanted to talk about working with United States Patent and Trademark Office, or the USPTO. A lot of people ask me questions about, hey, well, what do you do as a patent attorney, working with the Patent Office, and people who may be looking for patent attorney careers. They always ask me, like, hey, what do you actually do with the Patent Office? And I'm going to explain everything in this video, so stick around. We are starting right now. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So this channel is all about giving you insider information about patents. And so if you want more content like that, be sure to subscribe, hit that little bell icon so you don't miss any great new videos coming out. All right, let's go ahead and get right into it. There are two ways to start the patent process, and one is what is called a provisional patent application. And so the provisional patent application, that one you're not really doing much with the USPTO. You just draft it and you file it, and it's just a placeholder. It lasts for 1 year, it expires at the end of 1 year, and then you have to file what's called a non-provisional patent application. I mentioned the provisional because that's typically what I'll do with startups and new companies. But then you could start with the non-provisional if you wanted to. So with the non-provisional, you file it. It's the more complex application that has a lot of very specific filing requirements. So you file the non-provisional patent application at the USPTO, and then it waits in line for anywhere from 1 to 3 years before examination begins. And that's where the real work with the Patent Office begins. So when you file it, there's just some sort of pre-processing. There's really not much that goes on, and you file it electronically. Everything's really done electronically with the USPTO. I mean, you can file stuff in paper still, but we've really never do that anymore. Everything's going to be electronic. They have you can submit via PDF online. So again, you file, waits in line for 1 to 3 years, and then it gets assigned to one patent examiner at the United States Patent and Trademark Office, which is in Virginia. So the examiner picks it up, and it takes 1 to 3 years just because it's the government. It's really slow. It's just a big line. That's the only reason why it takes so long. Okay, so the examiner picks it up and does a prior art search to determine whether what you have claimed is new and non-obvious compared to the prior art that's out there. Okay, examiner does that prior art search, and then will form rejections in what is called an office action, which is a written description of what the rejections are. Okay, so everything's going to be it's going to be written. So the examiner is going to write down these rejections in this office action and mail it to you. And it used to be that they would mail these via physical postal snail mail, but nowadays it's mostly it's going to be electronic. All this stuff is going to be emailed to you. It's not really done via actual mail anymore. So you get this office action, or at least your patent attorney is going to get this office action, and then the attorney is going to do an analysis of the rejections and of the prior art. So typically there's going to be two types of rejections. There's going to be obviousness rejections, and there may be novelty rejections. Novelty is a question of whether there's one single piece of prior art that describes everything you have in the claims. Obviousness is, would it be obvious to combine maybe 2 or more prior art references to come to what your invention is? So that your attorney is going to do an analysis of the rejections and is going to decide how to respond to the office action. And one thing to note is that rejections are a natural part of the patent examination process. Think of it like Pawn Stars or American Pickers, where it's a natural part of any sort of negotiation. So that's a good way to think about it. You're negotiating with the Patent Office, and it's a natural part of that. It's actually a positive thing. Okay, so your attorney does the analysis, is going to determine how to respond to this office action. And there's 2 main ways you can do it. You can amend the claims to differentiate over the prior art, or what you can do is you can argue against rejections. And a lot of times you're actually going to be doing both of those things. Okay, so you can then file a written response with the Patent Office, but sometimes you can have a telephone call with the examiner. You can correspond via email. But really, in the end, there's going to be a formal written response that you'll submit with these formal arguments and potentially claim amendments. Okay, so you file this response, and then the process kind of continues. The examiner goes back, looks at your response and will do another prior art search. And let's say you're able to get over the rejections from the previous office action. The examiner may find new prior art that's relevant and form new prior art rejections. So this process can go back and forth, right? So the examiner, has new rejections, gives you a new office action. The attorney has to do an analysis and then file another response. So you could potentially go back and forth really indefinitely, as long as you're willing to pay more fees. Really, you could go back and forth a bunch of times. But a lot of times, it's only going to take maybe, 2, 3, maybe 4 back and forths. But sometimes, I've gone back and forth with the examiners 8 times, in a given case. Sometimes the examiners just don't get it, or they slow play it, or the client wants to slow play it, and it can take a really long time. Okay, so hopefully this negotiation goes well, and ultimately the examiner allows the case, you pay an issue fee, and then the application issues as a patent. All right. So one of the questions I get too is, okay, you're working with the patent examiners. This must be a contentious thing, and you're battling that with them. And yeah, there are certainly some attorneys who treat it that way, but it really shouldn't be like that. I mean, these people, they're not attorneys. They're folks who, may have an undergrad degree in some technical, technical background. They're not really, contentious people. They're not looking to, to stir it up if need be. And if anything, they're actually there to help you. So really, you should think of it as kind of a friendly negotiation instead of one, like with an attorney, or where it's, an adversarial kind of thing. Some attorneys take that tact. I'm not a big fan of that. I think you get a lot more done when you work with people and are nice to folks. But that's just kind of me. So, that's, kind of working with the patent office. A lot of it is written, but again, I'll talk to some examiners on the telephone, we'll email. There's also, more video calls that go on. That's more common these days as well. So hope you got some good information out of this video. If you did, please give it a thumbs up. I'd appreciate it. And if you want more patent content, be sure to subscribe to the channel, hit that little bell icon, and check out this video right here. This one you're gonna love. We got also all sorts of other stuff. Check out this one down here too. Also great content. So thanks for watching. We'll see you again in the next video.